Is this person going to testify? You cannot plead the fifth. The prosecution, as we saw the transcripts that were later released, kept pressing. You've got immunity. You cannot be prosecuted for this in any way, shape, or form. And that means you have to testify. Ultimately, that meeting was not expressed in detail to the defense until Brian Steele, the defense attorney for Young Thug, raised this issue. Following that, multiple defense attorneys filed motions for recusal. Now, moving on from the facts, going to the law, the legal framework for what a recusal requires. There are three criteria that needs to happen. Those being the motion needs to be timely, needs to be supported by an affidavit, and the facts alleged need to show that a recusal might be warranted. Now, to the first two parts, Judge Glanville himself said that this is timely. When the defense found an issue, they brought it up. The second part, he said that there's an affidavit that was filed. Good. But the reason why Judge Glanville himself said that he's denying the recusal is because he argued that the facts alleged did not warrant a recusal, that they did not meet that threshold. However, he ultimately passed this case on to another judge, and this is the judge's analysis and discussion. It's just a quick, I wouldn't even call it 2 pages. I'd call it a page and a half, if that. And the judge does start off by saying, as previously announced on the record, this motion was timely and supported by an affidavit. Already got that. But moving on to the next part, the court kind of pauses and says, you know what, it's worth noting, and I'm just quoting here, that this court agrees generally with Judge Glanville's assessment of the proprietary of the meeting, that ex parte meeting, saying, okay, that's okay to happen. While the meeting could have and perhaps should have taken place in open court, kind of giving that option there, nothing about the fact of this meeting or substance discussed was inherently improper. However, and this is the big however, in his order denying defendant Kendrick's motion and in the process of making a record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Just going to keep going through here. While, and I'm quoting here, may be appropriate for judges to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, said that the judge is not reasonably perceived as a hostile witness or advocate. As we saw in Judge Glanville's recitation of why he was not recusing himself, he was, let's just say he was definitely a little hostile. In presenting this record as to the recusal issues and in ruling on Kendrick's motions, Judge Glanville, quote, evaluated and accepted the truth of his own factual allegations mandating his recusal. What that basically means in English, he played both witness, judge, and jury in deciding the veracity and the truthfulness of his own allegations. A judge cannot do that. That's what the Honorable Judge Rachel Kraus, who was given this case to decide the recusal, ultimately decides. They continue by saying that this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but, and going on to quote here, the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. And this is the decision. Based on the foregoing, this court hereby orders the following. 1, defendant DeMonte Kendrick's motion for recusal of the Chief Judge Urville is granted. 2, Caleb Bumpus' motion to quash the show cause order and or for the recusal of Judge Glanville is denied as moot meaning that it's no longer an issue, and that the defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville for all further dealings in the above referenced case as amended and supplemented is granted. The court clerk shall reassign this case using the court's case assignment procedures. This is the order of the judge as of the 15th of July for the year of 2024. That is today. What that basically means is Judge Glanville is no longer the judge in the Young Thug RICO case for any of the defendants. It will go back to the court clerks to reassign this case. This is the breaking news coming out of the Young Thug case in Georgia. All right. So now that you have that breaking news and the breakdown of that 10-page motion, but I always tell people, you know what? Don't believe the guy in the nice suit. Go and read it yourself. But that is a quick synopsis of why Judge Glanville will no longer be the judge in this case. For now, we're going to go back to recapping the Alec Baldwin case, where his case was dismissed, ultimately because of arguments that the prosecution withheld evidence. Let's listen to Seth Kenney's testimony in that hearing from Friday.
And so each one had to ring clearly with the number 2 lead shot inside of it.
And of all the dummy rounds on all the sets, these ones had a muddy rattle.
No. The ones that were excluded had a muddy rattle.
I see. You provided 45 long Colt dummy rounds to the set of Russ, correct?
Yes. And more specifically, through Sarah Zachary. She picked them up.
Right. And you know Sarah Zachary was at your prop house on the 12th of October, correct?
Yes.
And you came back from Albuquerque, you came back from 1883 on the 11th, at least one trip, correct?
Yeah, I arrived sometime in the middle of the night, the night of the 11th. It could have been past midnight.
You've got to put it on. I think.
Is that okay?
Okay.
I'm sorry.
Thank you.
I know you want it.
You arrived the 11th.
Night of the 11th.
She comes the 12th.
Yes.
Shooting happens on the 21st.
Yes.
Russ needed 45 long Colt dummies.
May have needed. Knew they were running short.
Okay, they may have not needed it in the most of all time, but they needed it, right?
Possibly.
You have already told this court that you had brought 45 long Colt rounds from the set of 1883, correct?
The dummy rounds from the prop truck, yes.
There were also live ammunition on 1883, correct?
No.
There was no live ammunition on the set of 1883? Not on the set of 1883, at the cowboy camp, just off the set of 1883.
Not even close to anything that was filming.
Okay, so not anywhere close to filming, and not on the set, but at 1883's cowboy camp.
The cowboy training camp for 1883, yes.
Okay.
Live, yes.
And you brought some of those live rounds to PDQ, correct?
Yes.
The live 45 long Colt rounds to PDQ, correct?
Yes.
And you've told this court that when you brought them back, they were between 50 and 100, correct?
Yes.
Okay. And you provided 45 long Colts, again, you say dummies, I get it, to Sarah Zachary, correct?
Correct.
Those were Starline brass with nickel primers, correct?
Yes.
The invoice you provided to Sarah Zachary and the set of Russ had 200 listed as the amount that you provided, correct?
I don't recall.
Do you deny it?
Sounds about right. It could be. The invoice was generated weeks after, so it was done from memory at that point.
Okay. Have you been watching any of this trial?
Just the headlines, whatever comes on the news.
Okay. Do you know that on direct examination of CST Popple, that this was entered into evidence, which is States 30?
I haven't seen her at all during this trial.
Well, eventually on cross-examination, it turned out that these were, of course, the rounds provided, correct?
Except for the bright one in the lower row, in the middle, just above the 2 zeros that are next to each other. Yeah, in the evidence number, I don't believe that is a round that came from PDQ.
When you say you don't believe, which I think you said in direct, is you're not certain, but you don't believe, correct?
It's 2.5 years ago. It does not appear. I'm 99.9% sure that was not inclusive of the original styrofoam insert of 50 in the box.
Okay, so it sounds like you're not certain, but fairly certain, and it's been a long time. Is that fair?
Yes.
Okay. At the time, when your memory was fresher, you actually received a photograph of this, and you told Detective Hancock this, and it has a nickel primer, which is sketchy. Correct?
Can I don't know what the photograph is. A photograph of what?
Did you, in fact, tell Detective Hancock that that picture, that round, was sketchy?
I recall saying that, or texting her.